My name's Bill Rimmer. I'm chairing today's session. Welcome to the Greens List breakfast briefing. Today we have two barristers on the Greens List speaking on the Retail Leases Act and recent developments in the law of relief against forfeiture. Greens List is fortunate to have Rob Hay and Sam Hopper as barristers on its list. Sam Hopper is speaking first. Sam is amongst other things, a leasing specialist, has a detailed knowledge of the Retail Leases Act, both law and LAW and law LORE, through his work for the Small Business Commissioner and, of course, in the tribunal. Both Sam and our second speaker, Rob Hay, have blogs which many of you should now be subscribers to, and those of you who aren't should become so, in my respectful recommendation. The blogs are very informative on leasing law and property law generally, and also between the two they frequently engage in collegial debate on issues of or recent developments in the law. So I encourage you to join their blogs. So without further ado, I introduce you to Sam Hopper.
Thank you for the introduction, Bill. I'm pleased that I've finally achieved the status of Greens List, being lucky to have me on the list, because when I came to the list as a reader about 7 years ago, Michael seemed to suggest that I was the lucky one to be on the list. Bill's mentioned my blog, which has been running since about April. I'd encourage all of you to have a look at the blog. If you just type in Sam Hopper Barrister into Google, it'll come up and you'll be able to see the links to it. Subscribe to it if it's of interest to you. It doesn't cost you anything to subscribe to it, and so far as I can tell, your email address isn't passed on to any nefarious sources, and you won't receive large amounts of spam. You'll only receive the stuff, the little tidbits of information that I find interesting from time to time. If you're not interested in subscribing to a blog, though, I do also have an email mailing list that I send notes around to that cover general leasing topics. The blog's a little bit broader than that. It does touch on insolvency, particularly managed investment scheme insolvency, but the mailing list is confined to property-based issues, most of which are leasing. I'm going to circulate just a couple of pieces of paper with the very creative title, Sam Hopper's mailing list. If you want to be added to my mailing list, please put your email address in that page, and I'll collect it on that page, and I'll collect it at the end. Now, because we've got you here so early in the morning, before I launch into the details of some cases on relief against forfeiture, I'll tell you a little story. It's a story that one or two of you in the room may have heard before, but I always enjoy telling it. It was the story of my first leasing trial as a barrister. I'd been at the bar for about 4 weeks. I got a call from Michael at about 4:30 in the afternoon to go down to the Dandenong Magistrates Court, have a trial the next day about $3,500 worth of make-good costs that my client said was owing. I got the brief and I pored over it. I read the witness statements and I read the instructions and the pleadings, and I prepared my case theory. Like every good reader, I prepared my closing, then I prepared my opening, my evidence in chief, then my cross-examination, and then my opening, and I was ready to go. It's about 11:30 at night. I had my folder all set up. The adrenaline was rushing as I got ready for as I was preparing for my first big day. And I got home and I opened the door and went to say to my wife that I was home. Instead of saying, "Hi, honey, I'm home," I went, "Ah." I had completely and utterly lost my voice. And of course, I then went into a complete panic and started sending SMSs around to all of my friends from the readers course, and finally got a response from a mate by the name of Dave Gillard, who responded by calling me, and unsurprisingly, the conversation was a little bit difficult. He said, "Have you lost your voice?" I said, "Yes." He goes, "It's nearly midnight." I said, "Yes." He said, "You've got a trial tomorrow." I said, "Yes." He goes, "Well, do you want me to come and speak for you?" I said, "Yes." He said, "You know, I'm really pissed." I said, "Yes." He said, "You know, I haven't run a trial before." I said, "Yes." He goes, "You still want me to come?" I said, "Yes." So I picked him up about 8 o'clock in the morning, and I told him what the case was about, and we roughly had our case prepared as we whispered in the car on the way to Dandenong. And when we got to court, he got to announce the best appearance that I've heard at the bar. He said, "Your Honour, my name's Gillard, and I kind of appear for the plaintiff, but I don't have a brief. My learned friend, Mr. Hopper, he does have a brief, but he doesn't have a voice. And between the two of us, Your Honour, we make up a whole barrister." Anyway, we then actually interviewed our witnesses and found that not only did I not have a voice, but we didn't have a case. And we promptly settled for, I think, about $100 to my client, and we went away. Anyway, fortunately, that doesn't happen much anymore. But I've now... my topic today is recent cases on relief against forfeiture. Relief against forfeiture is one of those topics where the law is reasonably well settled and the same issues tend to come up again and again in cases. So recent developments is probably not the most accurate description, but what I thought I would do is address the following topics for you today, as far as I can within the time available. Firstly, the simple question of what is relief against forfeiture, a question that I get surprisingly frequently. Secondly, I'm going to detail some recent cases for you, and I've got 5 cases in the last 12 months that should give you an idea of how the remedy operates. I'll then give you some observations on those cases and with a view to extracting some lessons learned from the cases in the last 12 months. I'm then going to tell you about 2 areas where I think what you might politely describe as growth areas in this area, where there's some potential for future litigation. And the final thing I'll try and squeeze in before the end is a small tip for practitioners when drafting or settling leases. Okay, so what is relief against forfeiture? There's a very useful, there's a number of useful textbooks that discuss relief against forfeiture. I think the most useful for a practitioner, particularly one who's starting out in the area, is Chapter 9 of Parkinson's Principles of Equity. I should add also, there's not a paper at the moment in your materials. I've got a paper that I'll circulate in the next few days by email. I think Michael's got all of your email addresses. But Parkinson's Principles of Equity has got a very good introductory chapter on the operation of relief against forfeiture. But very broadly speaking, it works like this. A tenant seeking relief against forfeiture puts up their hands and says, "Mea culpa, I admit that I've done the wrong thing." They can apply to court before, but usually just after the landlord has re-entered and terminated the lease. They say, "I've done the wrong thing. I admit that the landlord has the right to terminate the lease and re-enter, and that the re-entry, if it has occurred, is proper. But the consequences of the re-entry so far outweigh the adverse consequences to the landlord as a result of the breach, or as a result of some other conduct, it is unconscionable for the court to allow the breach and the termination to stand. And the tenant asks the court in its equitable jurisdiction to pull out its very large equitable eraser and rub out not only the breach but the termination itself, and treat the lease as remaining on foot and never having been terminated." So when you're advising a client, particularly a tenant, on seeking relief from forfeiture, you've usually got to hose them down a little bit because they're quite angry and distressed. and you've got to explain to them that in actual fact they have to go cap in hand to the court and admit that they've done the wrong thing rather than going on the attack against the landlord, which is most tenants' ordinary reaction to a re-entry. All right, so recent cases. The first one I want to tell you about, I won't consider that, is a case in December 2010, the case of V&O Princi, P-R-I-N-C-I, and Prestige Holdings Group. If anyone's interested in the citation, 2010 VSC 627, a decision of Associate Justice Mukhtar. Now, in that case, the tenant had taken a lease of it was a bit like a median strip that expanded out into a larger parcel of land between two roads, and was conducting a car wash facility. The tenant had been in breach of a number of provisions of the lease. They had been was slightly in arrears of rents, but he'd been operating without a planning permit. He'd made alterations to the premises without the landlord's consent. He'd gone beyond the permitted use. Was conducting a dog wash rather than a car wash. Seemed to be conducting a used car sales business as well. The dog wash business was pouring waste into the local creek, which was breaching environmental laws, etc., etc. So there was a litany of breaches. The landlord re-entered and terminated without notice following a very short period of rental arrears, or a few days in arrears. The tenant tendered the rent the following day, but it was refused. He then went down with a pair of bolt cutters, cut the chains off, changed the locks to suit his new keys, and continued trading at the premises. There was also, the landlord then went down to confront the tenant over, and it seems like there was a short fist fight in the street between the two of them. And of course they had different versions of the events as to who did what to whom during that fight. Landlord then became shy about self-help for obvious reasons, and went to the court because on the tenant's own material the lease was properly terminated and the tenant was a trespasser. The landlord went to the court seeking an order for possession under the summary provisions in Order 53 of the Supreme Court rules. When the matter got to court, the landlord sought to press the application. I was acting for the landlord at that point. The tenant foreshadowed but did not make an application for relief from forfeiture. The matter was adjourned off and the parties entered into terms of settlement. The terms of settlement were reasonably complicated. They involved payment of all of the financial defaults and correction of all of the non-cash defaults in accordance with a timetable. And if the timetable was met, the landlord consented to an order for relief against forfeiture on the papers. If the timetable was not met, then the tenant consented to an order for possession of the land. When the tenant failed to meet the timetable, the landlord sought to press its application for possession. By the time the landlord then counterclaimed in a fresh application for relief against forfeiture, and both parts of the application were bitterly fought. Ultimately, the court found that it should grant relief from forfeiture. It should on the grounds that, firstly, the tenant paid the rental arrears, so all the cash breaches were remedied. The tenant had spent a significant amount of money setting up the business, and there was evidence that it was at least trying to find a buyer for the business. The business was a going concern. There was no evidence of the tenant's insolvency. And while the landlord had good reason to be wary or apprehensive about the future, based on, in the words of the judge, the tenant's unbusinesslike behaviour and cavalier and undeserving conduct, the landlord was entitled to take action in the future if the tenant continued to breach, and on balance, relief against forfeiture was the appropriate remedy. Okay, so that's case number one. Second case I want to refer you to is Primary RE and Great Southern Property Holdings, 2011 VSC 242. I'm not going to spend much time talking about that case other than just to refer you to it and give you the very briefest of sketches of the facts. This one might need a quick diagram. There is... Can everyone hear me if I'm talking like this at the back? Nods, yes? Okay, you've got a landowning company. You've got a head tenant who is also a responsible entity. A responsible entity is a form of statutory trustee that conducts a managed investment scheme under Chapter 5C of the Corporations Act. Beneath the responsible entity are a series of subleases to investors in the schemes that we know as growers. Both the landowning company and the head tenant were companies in the Great Southern group of companies. That group collapsed in, I think it was 2009, and liquidators were appointed to all of the companies, but so we had liquidators here and here, but we also had receivers and managers here. The receivers and managers wanted to sell the land unencumbered. So terminated that lease and sought a buyer here. Under the terms of various provisions of the Corporations Act, the growers were able to appoint a replacement responsible entity by calling a meeting of the scheme members. By replacing the responsible entity here, that says RE2 by the way, my writing's terrible. By replacing a new responsible entity, it effectively assigns from the old RE to their replacement all of the rights, obligations and liabilities of the old responsible entity under that were rights, obligations and liabilities in relation to the scheme. So if the lease had remained on foot, the old responsible entity would simply have stepped into the shoes, so the new responsible entity would have stepped into the shoes of the old responsible entity and could have exercised any relevant cause of actions in its hands. This entity here sought relief against forfeiture of the head lease. Now, there are a whole lot of facts and legal issues going on in that case. There was also one of the relatively one of the issues that was dealt with relatively swiftly by Justice Judd in the case was whether or not the court would have granted relief against forfeiture in that case. The judge decided that had he been required to, he would not have granted relief against forfeiture, largely for two reasons. One was that it took the growers a full year to get their house in order and appoint a new responsible entity in order to make the application. So the court was concerned about delay, and in particular delay in the context where the bank had found a buyer. So delay causing prejudice. The second issue was that the liquidators, at this point at the time the lease was first terminated, made public statements to say that they did not intend to and did not have the resources to rectify the breaches and seek relief against forfeiture of the leases. And it was in reliance on those representations, said the receivers, that they went out and sought themselves a buyer. So the two points I want to illustrate, I want this case to illustrate are one, delay, and two, representations by the tenant affected adversely the ability of the tenant to seek relief against forfeiture at a later point in time. Next case I want to refer you to is a much, much simpler case, mercifully. although at least superficially simpler. Well, it raises some more interesting legal issues. It's the case of, in fact this one is nice and simple, Lorgan Redlich. Lorgenredlich, Lorgan Redlich and Capadonna. This is a case in the retail tenancies list at VCAT. It was an application by the tenant Lorgan Redlich, who occupied a premises and was conducting a delicatessen business from the premises. The tenant had sought relief against forfeiture in September 2009, successfully. Went back into possession, continued paying rent, but defaulted again, and in March 2011, defaulted, landlord re-entered, and it again sought relief against forfeiture. There was at that time, in March 2011, a winding up application on foot against that company. So Deputy President McNamara granted relief against forfeiture on a number of conditions. One of those conditions was that the tenant arrange a standing authorisation from the Bank of Queensland for payment of rent not from the tenant but from a related company. And the idea seemed to be that it was to secure payment of rent to the landlord in circumstances that reduced the risk of a preference action by the liquidator if the winding up application was successful. The tenant continued to trade after relief against forfeiture was granted in March 2011, but the inevitable happened and it defaulted again, and on the 9th of August 2011 the landlord re-entered and a third application for relief against forfeiture was made. Now finally, after 3 applications, the landlord was successful in resisting the application for relief, and the tribunal, in refusing relief, relied largely on 5 pieces of evidence. Firstly, the company search of the tenant company showed that there was not a second, but in this case, by this time, a third application on foot to wind up the company. So there was a very, very significant risk of this company being placed into liquidation. Secondly, the condition on the previous winding up order for relief against forfeiture was that the tenant provide the standing authorisation from a related company to pay the rent. The standing authorisation had in fact been provided, but the rent was not being paid pursuant to that standing authorisation. It was being paid from some other source. So although the tenant complied with the letter of the condition, it failed to comply with the substance of that condition. The excuse me. The third thing was that as the evidence unfolded in the case, it became clear that the tenant was late in rent because it couldn't pay the rent out of its own cash reserves. It had found a buyer for its business and it was waiting on the provision of the deposit on the purchase price in order to pay its own rent. So that, of course, created some discomfort in the mind of the court. Then when we examined the contract of sale of the business, it turned out that the vendor of the business at the premises wasn't in fact the tenant, it was another related company. So it seemed that the tenant was selling the business from a third party in order to bypass the tenant itself and presumably prevent the petitioning creditor and the winding up application getting access to those funds. And finally, all of that material came out, or most of that material came out in cross-examination. So the tribunal was concerned about a lack of full and frank disclosure by the tenant. So I decided that was it, enough's enough, no relief against forfeiture in this case. I've just got the bell from Bill, so I'll tell you very quickly about the final case, which there's two decisions in the last few months in the cases of Lon Tav and Pine Ross. The first decision was one of Justice Hargraves, the second was one of Justice Dixon, and I'll give you the details in the paper when I circulate it. Again, two cases of relief against forfeiture. The first was termination for a number of breaches, including failure to pay rent, failure to pay interest, and failure to increase the security deposit. Relief against forfeiture was granted the first time on condition. There were a number of conditions, but one of them, importantly, was that the tenant transferred back to it a liquor licence for the premises, which was at the time held in the name of another person. That was important for a number of reasons. Anyone who does liquor licensing law will know what they are. The tenant moved back into the property, continued trading, but six weeks later the lease was terminated a second time because the tenant continued to trade without an appropriate liquor licence. It was in somebody else's name and he'd failed to transfer it back. There's quite a complex process of reasoning involved by Justice Dixon in the second decision, but the long and the short of it is that the tenant had failed to comply with the condition of the first grant of relief to transfer the liquor licence back to the tenant's name. There was no reasonable prospect of that occurring in the near future, and that was not only a breach of the lease, but was a breach of statute that was attracting penalty provisions, and the liquor licensing police were starting to get involved. So again, relief against forfeiture not granted, and the tenant lost its tenancy. I'll give you some quick observations on those cases and some conclusions that I've drawn. These conclusions aren't supposed to take the form of a textbook on the law of relief against forfeiture, but just some lessons that come out of the most recent cases in the area. Firstly, when you're acting for or advising a tenant who's going to seek relief against forfeiture, there's 6 points that I want to make. Firstly, seems fairly obvious, but advise your tenant to make every effort to correct any breaches of the lease before an application for relief against forfeiture is heard. Number 2, the breaches should be remedied and an application for relief against forfeiture should be made as soon as possible. Don't find yourself in the position of the growers in the Great Southern case who were making their application a year later. 3, if the breach can't be remedied, at the very least seek instructions to give an undertaking to the court that any outstanding breaches will be remedied. Fourthly, be prepared to provide to the court some proof that your client's undertaking has some substance, and that in fact it's possible, and preferably probable, that the breaches can be remedied. Number 5, have some evidence of the tenant's solvency available. And number 6, advise your tenant that obtaining an order for relief and forfeiture becomes substantially more difficult after relief has been granted the first time. 3 points for when you're advising a landlord. Point number 1 is this. It's prudent to advise your client that relief against forfeiture is likely to be granted at least the first time, especially if, obviously, the tenant can rectify the defaults, but particularly if the tenant's goodwill is valuable, the tenant's invested a significant sum in the business, and the tenant's trying to sell their business. Point number 2, in fact, I've only got 2 points, sorry, I'll correct that. Point number 2 is that you should, so far as possible, try and obtain evidence of the insolvency of the tenant well in advance of your re-entry and the relief against forfeiture application, particularly if there's cash breaches involved. I should add at this point, most relief against forfeiture applications are dealt with very quickly and on a summary basis. So having the evidence of suggesting that the tenant's insolvent well in advance would serve your clients well. The final point, and I know I'm out of time, Bill, but I'll just make my two final points quickly, and they are, firstly, potential growth areas for future litigation. Justice Dixon in the Lontav case gave an opinion on the ability of a tenant to seek relief against forfeiture having failed to exercise its option within time. Can you seek relief against forfeiture of an option? There have been 3 Victorian cases in recent years suggesting that perhaps you can seek relief against forfeiture of an option after failure to exercise. There's a long-standing academic debate on it, and Robert and I have debated it at great length from time to time. Justice Dixon suggests that you cannot seek relief against forfeiture having failed to exercise an option. I don't think Justice Dixon's view is the last word on the topic. I think there's still some room to move, and I think there's still an arguable case in there. I won't take you through the details of it at this stage, but I'll put the materials in my paper for those who are interested in reading it. But the take-home point for practitioners is that if your tenant has failed to exercise an option within time, there is at least an arguable case that they may be able to seek relief against forfeiture of that option, provided the time defalcation is not too great. The other area that I think is interesting is the possibility of seeking relief against forfeiture of a franchise agreement after default. Most franchise agreements, or the standard form franchise agreement, is that the tenant the franchisor takes a head lease of the premises. The franchisor then grants to the franchisee an outlet licence coupled with a franchise agreement that grants certain intellectual property rights. There's a line of cases starting from a decision of Justice Young in the New South Wales Supreme Court suggesting that relief against forfeiture of a bare contractual licence as opposed to a lease may be available when there's a right to seek specific performance of the contractual licence. And there's also a line of cases suggesting that relief against forfeiture of property rights such as intellectual property may also be available. So between the two of those, I think you can mount a reasonable argument that a terminated franchise agreement and licence agreement may be the subject of a relief against forfeiture claim. Finally, I said I'd give you a drafting tip at the end of the paper. Drafting tip is this. One of the issues over relief against forfeiture of an option is that an option, unless the drafting suggests otherwise, is an irrevocable offer that can be accepted by the tenant on exercise of the option in order to create a new contract for the creation of a new lease. The main difficulty that Justice Dixon had in the Lontav case with the possibility of seeking relief against forfeiture of an option is that the option is an offer and doesn't itself create a property right. It's at least theoretically possible to draft an option as a conditional grant. So rather than merely calling it an option, you'd need to make it clear in the document that the option is a grant. The option is a grant which crystallises on fulfilment of certain conditions. If, when acting for a tenant, you can make amendments to the lease that create a conditional grant, then you will at least be better placed to argue for relief against forfeiture if the tenant fails to exercise that option within time. So that's the drafting tip for people acting for tenants. Try and bring it in try and have the option drafted as a conditional grant. Obviously, when acting for landlords, you'd want to resist that. That's all. Sorry I've gone over time. I've taken a bit of Robert's time, but thanks for listening to me.
Thanks very much, Sam. Sam will be available for questioning after Robert's paper as well, Robert.